Welcome to Euractiv's Tech Brief podcast. My name is Luca Bertuzzi, your technology editor. This week, we take a closer look at the Data Act and at the state of the policy discussions. For an overview on all things technology in the EU, sign up to our free newsletter or visit the website euractiv.com. This is Euractiv's Tech Brief podcast. Today, I'm joined by Heiko Richter, Research Fellow at the Max Planck Institute for Competition and Innovation. And we are here directly from Berlin, where for the Data Summit, we just had an interesting discussion about the Data Act and how to make it fit for purpose. So I just turn the question back to you, Heiko. How do you think that we can make this regulation work? And what are the critical points that we need to correct at this stage?
I think it's a very ambitious regulation, and for this reason the complexity is very high, and the risk is to not see that in some details that there are big questions that lie in these details. And in my view, what I would support is a horizontal approach. I think it has been prepared over, the first discussion started over 7 years ago now, and actually in another disguise was the data property or data ownership debate, and turned into an access debate, which I favor very much. And also the horizontal approach is meaningful and to be supported as long as it leaves enough flexibility for taking the sectoral specifics into account. So that would be the first plea to say that the result should be a horizontal regulation that leaves flexibility. Now, the question of horizontal regulation is always what is the common denominator? What are principles that are basically applicable to the scenarios of data sharing that we see and that we want? And I think upfront is the very important question that is not clear from the Commission's draft. And as far as I see it, the political discussion is also not taking sufficiently into account on this very conceptual level, is what is this access right for that is in the Data Act? What should users be able to do with the data? What should third parties be able to do with the data on basis of this access right? Of course, that's a mandatory right. So besides that, there is always the possibility of voluntary sharing and going beyond this. But what do we want to reach with this access right? And I think if we clarify this first, and I don't see a clear and straight line in this yet, then we should continue with such questions as which data is actually in the scope, which should fall without the scope, how to trade secrets, what about the technicalities about access, how to treat SMEs, and so on. So first, get the concept straight. And there are basically two, I wouldn't say opposing concepts, but two very different concepts. One would be to limit it to certain purposes and interests. That means attaching the access right to only some specific cases and uses. In particular, secondary value-added uses and services on secondary markets, or framing it rather the way of co-generation of data, meaning that because I have generated this data, I'm entitled to do whatever I want with the data, and the data holder is not. So these are the two basic concepts. And I think this question you have to answer first before going into the details of definitions, data holders, data users, and so on. So clarifying all the vagueness that is in the draft.
I would agree with you that there is some vagueness and some ambiguity in the initial proposal by the European Commission. But perhaps if we want to look at the purpose of what the Data Act is trying to achieve, we should look at what it's building on, so the Data Governance Act. And there you have this idea of creating a sort of market from scratch for data intermediaries. And to create a market, you need also to monetize the data. So you have the aspect of how you attribute economic value to personal data and how you make it a tradable asset. So this is somewhere there, but it's not really developed in the regulation.
totally agree. And the question is, should this be developed or effectuated also in the frame of the Data Act? To be honest, I was really puzzled when I had first looked at the draft Data Act, because the DGA is not really mentioned. So it does not explicitly hint to the DGA. And I think that's a quite seminal piece of legislation that took a lot of effort. So why making the first step, and the second step does not really refer to it? Now there are two possibilities. One is that it is implied, so that basically means they somehow interact, but I don't refer to it explicitly, or, and that would be that now for the legislator to clarify, I insert stronger links to the DGA, and this goes back to the first comment I was making. If you follow the model of that, basically, or if you ask the question, what can be done with the data? What role do intermediaries play for it? It is a big difference if you conceptualize it as a purpose-based right or as a sort of rather a property right, where you can give your data also to an intermediary, and then the intermediary commercializes the data and you get some money back for that. I'm not sure if this is wanted, right? The Commission rather focuses on secondary purposes, so intermediaries might help to effectuate these secondary services, but they have to serve the user, basically. So they are not merely there for commercializing the data and to reaping off some monetary flows. But that's open for discussion. I know that the political discussion, that there are different proposals, and depending on how you see that, will decide on what role the data intermediaries can play.
And again, I mean, the Commission, of course, had its own view, but then the legislative process is out of their hands. And if you look at what happened with the DGA, it turned into quite a different beast compared to the original proposal. I want to go a bit deeper in terms of what you said. It's horizontal legislation, but we will have to consider sector specificities. The industry just said that one-size-fits-all approach won't work. So how can we make it work? How do we capture the complexity of the IoT economy, where, data holders are not necessarily the manufacturers? So there is quite a lot of complexity that perhaps needs to be built into this act.
Yes, absolutely. That's the $1 million question, basically. And you see it with these definitions that sometimes you have some pre-notions in mind. I think there are some examples that are often mentioned. It usually starts with some farming devices or smart tractors, and you often have predictive maintenance as an example. And it seems that somehow the whole regulation does build on some prime examples, but there are certainly hundreds and thousands of uses more than we have thought of and than we can imagine, because this regulation should be future-proof. So the question of making it targeted, but not following a one-size-fits-all approach, I think you have to think about some basic differentiations that you could include upfront in this Data Act. One would be, is business to business another animal than business to consumer? At least this is what is discussed. I think it's not necessarily business to business or business to consumers, but it can, when it comes to legal details, as for example, how to treat contracts, it is. But in the real world, it can also make a difference if it's a mass device, or if it is a unique device, or if it's a custom made device. For understanding whether I have to differentiate or not. I think what is very crucial is Chapter 3, because it tries to establish the FRAND principle for statutory data access. That means for all data access rules in the future, this FRAND principle should be there, unless and a sort of an opt-out, unless sector specifics establish a different standard. And then the question is, can these sector specific rules basically do they have to build on a minimum standard that is given in the Data Act, or can you derogate basically these rules? That's a very, very crucial questions, and we do not know in the future. So I think as a default, it's fine if you can derogate from the standard. I would say you would need at least a justification. So this would leave some flexibility, or more flexibility than saying, well, this is the baseline, it always has to be like this, no matter what comes. If you don't want this baseline to be established, or if you want to make it permeable, so to say, then you would need some justifications, and especially the reasons for these justifications, they have to be outlined and also be able to be scrutinized. I think that would be one way to also give some flexibility, while at the same time establishing horizontal rules. We do have the same problem actually in open data legislation, where you say these are horizontal rules, but there are maybe some high value data sets that are very valuable. So what to do with them? There you have a special set of rules. You can provide a framework of the criteria if that more targeted rules should fit. But that's also a very abstract exercise. So I can understand if this is for the legislator maybe a little too much to install now. If I may add this, and coming back to the Data Act, what I'm not entirely sure is that the application of this friend chapter 3, so this is not only for chapter 1 and 2, for the IoT access, this should be a general regime established for the future for all data access regimes. But I'm questioning whether this chapter 3 standard is actually appropriate and suitable for applying it to chapter 2 access, basically. So there I see a problem.
Speaking of complexity, are we comparing pears and apples when we are talking about B2B and B2C? Because I mean, there needs to be some differentiation of where the data is going. You were also hinting at the contradiction in terms of compensation in this regard. So how can we make this distinction better?
I think the compensation matter of compensation is a conceptual problem of the Draft Data Act. I think the way I read the Commission's draft is that the user gets the data for free and can use it for any unlawful purpose. At least this is what recital 28 says. And then recital 28 continues and says, as the prime example for using value-added services. But the first sentence is for any lawful purpose, no compensation. Now, the third party, however, a third-party recipient should compensate for the data. Now, obviously, one way to circumvent it, the user gets the data for free and passes it on to the third party. So it doesn't make sense. In this case, you would circumvent the compensation obligation for the third-party data recipient that actually Article 8 imposes in combination with, I think, Article 5 or 6. One way to solve this problem, as you asked, is treat both alike. That means either user and third party have to pay, or none of them has to pay. Now, if you ask the industry, well, might also depend on whom you ask, right? If you ask, so the industry is, of course, not really clear. It depends on which side you stand. I would say, and basically I have to disclose, at the Max Planck, we wrote a quite comprehensive position statement that in a wonderful team. And this proposed solution is there is no reason for compensation in this case. Especially Friend makes everything much more complicated. It can lead to holdup. And there are also ways to basically pass on the costs. So if the argument is that costs occur on the device, but then again, it depends also on whether it is business to business or business to consumer device. But to make this rule simple, the answer in this case would be no compensation in any of the case for the user and the third party recipient.
Now, to move on to the matter of the type of data that should fall under the scope. This is really a key question, of course. And speaking with someone that was working on this in the parliament, the person told me that there are two ways to kill this legislation. Either you either make everything about trade secrets to the point that the data you receive has no value, or you make it so much about raw data that, again, the data has no value. So there is a lot of discussion about transmitted data, even about the devices that should be considered in scope, or the related services. There doesn't seem to be a common understanding on this concept, at least in the parliament yet. So how can we frame this debate in a way that makes sense and makes the data work?
I would totally agree with what you said. These are two ways to kill it. But I can also understand if the data can be used for everything, that there is some understandable concern of the industry that they might lose the trade secret or have to disclose the trade secret. And the second question is which data. And in my view, both questions are related because they relate to the question, for which purposes can this data be used? If the purpose is well defined on an interest-based concept, then you would say, I think it's consequential then to say this purpose has to be reached. What does this mean? Let me give you an example, because sometimes the discussion is very abstract. So let's take a fitness tracker, a device. Now, you might want to have data how many steps a person made one day while walking, and this data might be very important for offering some other apps, value-added service, and so on. So you want to have access for this purpose. Now the question is how to classify this data, how to classify whether this is step or not. I mean, one question is this stored on the device or is this sent to the cloud? But my question is how to qualify this data. Now, you could argue, well, this is only observed data. Is this raw data? In my view, no. It can be inferred data, because the question if something is a step or not, that is nothing that the sensor tells you, right? There's maybe an electric impulse, so it's a 1 or a 0, and then there has to be some calculations, and the better your algorithm is, the better the device can understand this is a step or this is just a coincidental bump because I was sitting in a car or something like that. Now, if you understand this as inferred data, I mean, if you ask technicians, they also have their opinions, but if you would say this is inferred data and this would be out of the scope of the Data Act, it would be entirely useless. And this is only about if this is a step or not. This is not about trade secrecy here, where you can derive anything about the algorithm, the data set, and so on and so forth. So in my view, if the purpose is clear what I want to do with this data, then the data that should fall under the scope of the Data Act should be broader. And the fact that you say, well, it should not be in because it's IP protected, there you really need to have a close look of what IP protection you're talking about. Are you talking about database protection? Well, this is actually sort of overruled by Article 35, so that's not a problem. Is it about copyright? Well, there is software protection, but I have to ask how this should be affected. Is it about patents? But it's absolutely not clear up front that it's protected. The other question you were asking about trade secrets, because this is also related. Yes, there is this problem or this dilemma that one way to kill it is to say trade secrets are respected in a sense that if I claim that these are trade secrets are involved, then this data set is not affected under the access rule. And for this reason, I think it's a reasonable approach. As far as I read it in what the Commission proposed is, well, we respect trade secrets, but you also have to take measures to protect the trade secrets and disclose it. And for not losing it, then you have to accept confidentiality agreements and so forth. I think this is the right approach. And again, this is also, I think, an approach that is justified in case the purpose is clear. As I said at the beginning, I can understand that if now users can use such data sets, and if you have a broad definition of the data sets, which I said, and then also make sure that you have confidentiality agreements with any third parties and users, the likelihood significantly increases that you will lose the trade secret. But trade secret is a legal concept, so it's not natural law that something is a trade secret, and this gives you flexibility on the one hand. On the other hand, poses the risk that it can be strategically abused.
Indeed, and I think that if policymakers don't get this right, or at least the text is not clear enough, there is a concrete risk that this will land on the desk of lawyers, and that they will do their best to avoid that their clients don't fall under the scope.
But lawyers will also do that if the law is clear.
Well, at least Brussels is doing a very good job at keeping lawyers busy, as well as other categories like lobbyists. But just to conclude, I think the Data Act is quite unprecedented insofar as it tries to create a market that isn't there, except maybe in a couple of Scandinavian states. So there is also a concrete risk that, you'll have a beautiful legislation on paper that never gets applied in practice. What is your suggestion or your message for policymakers to avoid this pitfall?
Think about implementation. So sometimes it's helpful to think about implementation in concrete examples before thinking about, or while at the same time thinking about these abstract rules. I think it should not be an afterthought of how to make it work. There is a tendency to establish hard law and then to shift all the little details that make the big difference to soft law and leave it to other bodies to decide because you cannot achieve political compromise. And in my view, it is a Hercules task for sure. As I already said, I think access rights go into the right direction, but to make them work, keep them simple. Don't overload them, and especially have consensus on the very, very basic concept that you want to achieve. I hope that the result will not be a compromise that waters down the whole piece. I'm not saying that it is clear now up front. At the same time, the word clarification is maybe a little too marginal when you see that in these details there are actually big questions behind. So my message is be concise and also strict about the general concept, but less is more, and don't overload it with some wishful thinking that does not match the market realities, while at the same time keeping it open and make it future-proof. That now sounds like squaring the circle. I'm happy I'm not a policymaker, but in this particular case, I really see the risk that it gets overloaded. I wish everyone good luck and good success, especially with the ambition to have what was that negotiating mandate until February or March in the parliament?
Yeah, so the plan is for the industry committee to vote in February, and for the internal market committee in March. So, as you say, it's a complex file, and probably quality should be prioritized over speed. But at any rate, that's all we got time for this week. I would like to thank Heiko Richter, Research Fellow at the Max Planck Institute for Competition and Innovation. Thank you. That's all we got time for this week. Don't forget to sign up to our free Tech Brief newsletter to stay on top of tech news and digital policy developments in the EU and beyond. Also, don't forget to subscribe to this podcast, published on Apple Podcasts, Spotify, Stitcher, and Amazon Music. This episode was produced with the technical help of Evi Chiori. I'm Luca Bertuzzi, and thank you for listening.